As you are aware, Wycliffe Oparanya was nominated to be a minister for a cabinet secretary for cooperatives. His name has been forwarded to Parliament. He's supposed to be vetted on Sunday, and if successful, he be confirmed and appointed and sworn in as a cabinet secretary in the government of Kenya. Before that time, my client had been investigated maliciously by the Eacc, and a file was recommended to the DPP. Before the file went to the DPP, the Eacc arrested my client. We went and demanded to know why they are arresting the former governor then, before the file had been approved by the Director of Public Prosecution. Our client was released. They continued doing their investigations. They forwarded the file to the Director of Public Prosecution, who approved the charges. We were not satisfied that the charges can stand. So we rushed to the High Court, got conservatory orders to stop the prosecution of one Wycliffe Oparanya. After we got a stay, a conservatory order, we wrote back to the Director of Public Prosecution to review the file. We provided exonerating evidence. We provided evidence to show that the former governor was completely innocent. We provided bank statements, sale agreements, purchase agreements, and all the accounts of the larger Kakamega County, and the DPP undertook to review that file. The DPP reviewed the file. He forwarded the recommendation back to the DPP, to the Eacc, to do further investigations. The Eacc did further investigations and forwarded a complete file to the DPP. The evidence that was presented was not sufficient to charge the former governor, and the DPP wrote back advising Eacc to close the file and mark that file as being no action from the Eacc. There was no sufficient evidence to do that. Fate as it is, Oparanya was nominated. The Eacc wrote back to the DPP declining and saying they are not satisfied. We didn't see under which section they could have written back to the DPP saying we are not satisfied with your decision. Still moving further, they wrote to the clerk of the National Assembly saying that they have not cleared Oparanya and they are objecting him being vetted. He should not be vetted because he is a person who is supposed to be charged with the criminal offenses. We have written back after receiving instructions today in the afternoon. I have written back not to the Eacc now. I have instructions from my client Oparanya to sue all the commissioners and the CEO in their own capacity, in their own names, because they are not acting under the laws of the Eacc. The Eacc is a constitutional body, just like the DCI, the police, that are supposed to investigate. After investigations, their job ends there. It is the Director of Public Prosecution, pursuant to Article 157, who decides to charge, not to charge, to take over private prosecution, proceed, or terminate. And under Article 157, the Director of Public Prosecution, one now sitting, Renson Ngonga, cannot be directed, not by the President, not by the Cabinet, not by the CDF. Nobody can direct the Director of Public Prosecution. His decision is final. A similar decision with the Balala matter, which is final. He has decided to withdraw. A similar decision to the governor, to the cabinet nominee, which is final. Where does the DPP get this power? Article 157, 111 says that the DPP can review any file, and if he finds that the prosecution is malicious, the prosecution is going to be a miscarriage of justice, if he finds out that it is not in the interest of the public good, he will terminate that matter. Under Article 157(6), he is supposed to seek the permission of the court. This matter had not gone to any court of law, and the Cabinet Secretary had not taken plea. Therefore, the DPP, is not bound to seek that permission from the Eacc boss. I do recall very well the DPP who is sitting and I appeared together for interview before Twalib Mohammed. He is a member of the Public Service Select Committee that interviews directors of public prosecution. If he thought Mr. Renson was not qualified, then he could have objected Mr. Renson Ngonga to be appointed the Director of Public Prosecution. So long as the Director of Public Prosecution is there, he enjoys a security of tenure of 8 years. He has done 1.5, and he will continue doing with that. So we are doing papers from Nyamira here. We are working on the papers to go to court, and on Monday we shall sue and seeking compensation in form of defamation, because they have defamed the Cabinet Secretary that he is corrupt. Under the Kenyan law, Article 49 and Article 50 provides that it is only a court of law competent that can declare somebody unfit or somebody to be corrupt. The Eacc is calling Oparanya corrupt. It is not tenable, it is recklessness, it is unprocedural, and that is why I'm in support and serious support of the Eacc Amendment Bill 2024, which says the CEO and the chairman of Eacc must be an advocate who is fit to be a judge of the High Court of Kenya. That person must have practiced law for 10 years and above, because what we are seeing is a complete ignorance of the law, complete misunderstanding of the constitutional mandate of Eacc, and we shall be moving to court with speed. I will give the Fourth Estate a letter that we have written to those people in their personal capacity, and we have served the clerk of the National Assembly.